Well, it's here, what we've been waiting for, this motion for a stay of the bombshell that Jack Smith was supposed to drop today in the Washington, D.C. election interference Jan 6 case. And Donald Trump is terrified, doesn't want this evidence out in the public before the election, absolutely terrified. And so they filed this motion for a stay so that the judge does not allow this evidence to come and show you, all of you, before you vote, what the evidence is that Donald Trump tried to steal the election and caused this riot and this insurrection as part of his effort to steal the election and prevent Mike Pence from certifying the election. That is what is going on here. That is what he has, Jack Smith filed. Now, let's talk about what exactly is going on. So if you recall, what is going on is, in the context that we're in, is that the United States Supreme Court in July, I think it was July 1st, ordered Judge Chutkan to do a factual review of all of the evidence to determine whether or not former President Trump is immune from criminal prosecution. And so the Supreme Court chastised, frankly, the lower courts, both Tanya Chutkan and the D.C. Circuit, the Circuit Court, which is the intermediate appellate court below the Supreme Court. The Supreme Court kind of chastised both of them, saying, you didn't do a factual record to determine what is immune from prosecution and what isn't. Because don't forget, they created these categories, these three categories, right? Things that were core presidential duties, absolutely immune. Things that were personal, not immune, and you can prosecute. But then there's things in between that you have to determine, was this part of his job description or was he acting as a candidate, right? And so you didn't develop that factual record because some things might go either way. And so they ordered, essentially, Jack Smith to do this and ordered the judges to do this. Well, Donald Trump doesn't want the facts out there. He doesn't want you to see the facts. He doesn't want the facts in the public record because the election is 3 weeks away. And by the way, that's not Jack Smith's timing. Jack Smith's been trying to do this for way before the election, for months. All of this is because of the appeals by Donald Trump. And he desperately doesn't want these facts out there because his end game is to hide this from the voters, win the election, so that he can dismiss the case against himself and immunize himself, pardon himself, right? And all his friends and family and everybody else that did this. Okay, so that's where we are. And so Jack Smith filed this very big motion last week with an appendix, right? Remember the motion where he said, "Oh, Judge, can I have more than the 40-page limit to submit this to you? Because there's a 40-page limit in submitting motions." And the judge, he said, "Oh, I have about 180 pages." And so he submitted this giant document that had all of the facts in there. But there was an appendix, a huge appendix that had all of the evidence supporting the facts. It's one thing to say something, right? It's another thing to prove it, and to prove it with facts. And the appendix was sealed, and they had until today. Donald Trump was he was exploring his litigation options. So he filed a motion to explore his litigation options. Well, he finally filed this litigation because he desperately does not want these facts out there. One other thing, by the way, and we were all wondering, why is it that they were asking for more time to file their motion, right? Because we have Jack Smith's giant factual record out there. Why is it that they're waiting until after the election to file their side of the story? Now we know why they did it. And the reason they did it is because this motion that they just filed minutes ago basically says we don't want them to file their appendix with all their evidence, right? It's like all their attachments, all their attached proof, until we get to also file our attached proof. We don't want one-sided. We want to file stuff that proves our side of the story. They want to have essentially a trial, a public trial out in the open. They want to be able to do it that way. But that's not how things work. Things work like the way it's happening, right? Jack Smith gets to file all of this and get it out there, and then they can do theirs too. But they absolutely don't want it. So they were exploring their litigation options, and they filed a 7-page motion. It's President Donald J. Trump's motion to continue stay of the order, because it is temporarily stayed, by the way. It was supposed to come out today. And so it basically says they respectfully request the court to continue its stay through November 14th, 2024. After the election, okay? And the background, they say, is, look, on September 26th, special counsel sought leave to file its immunity brief and its accompanying appendix, and the special counsel represented that it had redacted non-public sensitive materials in their entirety, but they said the appendix still contained other materials. Trump objected to the public release of the filing, and then they basically complain about it, and they say the Constitution, as well as the rules of criminal procedure, do not permit the special counsel to preemptively defend its own lawless superseding indictment prior to any defense motion, and 2, publication of cherry-picked materials, which the special counsel describes as detailed statement of its case, would prejudice potential jurors and endanger potential witnesses, especially in light of the extraordinary media coverage of this case and the presidential elections that is less than 3 weeks away, and also irreparably harm President Trump. So basically, they're desperate, and they're saying, please don't file this. And so and they basically are saying, look, the court has inherent power to temporarily stay proceedings, including implementation of an order, and deciding whether to exercise this judgment. The court must weigh competing interests and maintain an even balance. I'm reading from the motion right now. And thus, when determining whether to grant a stay, they should examine factors such as whether a stay will prejudice or tactically disadvantage the non-moving party, simplify the issues and streamline the trial, reduce the burden of litigation, et cetera, et cetera. And here they say, can you please briefly continue the existing stay of this appendix, this bombshell evidence, right, of everything, because they think that these cherry-picked documents will prejudice potential jurors, because it's one-sided, it's an inaccurate picture of the case, and those same potential jurors may not see President Trump's later responsive filing, and even if some do, first impressions are prone to remain. So they also say the appendices are they want them released simultaneously. So do you hear that? Trump's motion to say why he's actually immune from prosecution is not coming until after the election, and he wants to file his evidence as part of that motion. And he says, don't file your evidence until I get to file mine too, because I want everyone to see both sides. He's trying to have a trial in the court of public opinion, not a trial in a court of law. That's just not how it works. But he basically says, look, asymmetric releases exacerbate the very harms that immunity exists to prevent, including the prospects of criminal prosecutions, chill him from taking bold and unhesitating action required, blah, blah, blah. So they go on and on using language from the Supreme Court's decision. But you know what else they cited? They cited 2 articles from legal commentators, Jack Goldsmith, and Ellie Honig. Okay, and Ellie Honig has been really coming out and criticizing Jack Smith for doing what the Supreme Court ordered and doing what Judge Chutkan ordered, which is filing motions. I don't really understand why people why Jack Goldsmith and Ellie Honig think that Jack Smith could have done anything else when this is what the court has told them to do. I mean, that's what you do. They're citing this DOJ 60-day rule that you're not supposed to disclose things that could, if you have a pending investigation and there's an election, you're not supposed to take action that will influence the election on like a pending investigation. But if you already have a prosecution, it doesn't apply there. But they cite language in the Jack Goldsmith New York Times article. It says, the department could have asked the judge to do something after the election. It's hard to understand why they're going forward now. And so they cite these articles that so many people have come forward and widely panned this claim by Jack Goldsmith and Ellie Honig that that the 60-day rule actually says this, that they shouldn't have done this. So most people with experience, most people who are former prosecutors, scratch their head at this claim. But I guess intelligent people can disagree. Both of them are very serious, intelligent people. But I've heard people like Preet Bharara, who was Ellie Honig's boss at the U.S. Attorney's Office, Joyce Vance, who's a former United States attorney in, I believe, Alabama. They all come forward and has said they highly disagree with this assessment that the DOJ 60-day policy is not even really a rule, does not apply in this circumstance. And frankly, it really is all about doing what the court tells you to do. If the court tells you to file something, you're not supposed to not file it. This is the schedule that the court created. And the court is very aware of things like election timing, et cetera. And so it makes no sense. But anyway, so going back to this filing, they're basically very desperate to get the court to stay this proceeding. They said, don't allow this evidence to come out now. And they're very desperate. And so that's what's happening. We'll see what Judge Chutkan does, whether she continues to stay it or whether she releases the appendix. I think that she will make a very quick decision, and we might even get the bombshell appendix today. I don't think the election and them wanting to file their motion is a reason to do it, that she will agree to that. So let's see. Hopefully we'll get to see what the evidence Jack Smith has against Donald Trump. It must be really, really damning for them to be this desperate to keep it out of the public opinion. I'm Karen Friedman Agnifilo. I'm a co-host on Legal AF. Watch us every Wednesday and Friday, and watch the new hit podcast Mistrial every Thursday. And hopefully it's dropping later today at 6:00 Eastern time. And hopefully we'll have this bombshell that we can discuss with you at that time. And make sure you subscribe to the new Legal AF MTN YouTube channel. It's free to subscribe. Thanks so much for listening.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.